Hello again, I'm attorney Robert Flesses for Robbins & Lloyd Career Training Institute. You're watching the first of 4 parts of course number 2, Disciplinary Actions. In this 4-part course, we'll be discussing how disciplinary proceedings are conducted so you have a basic understanding. Then part 2 will discuss case studies, and part 3 will be pathways to professionalism to maintain courtesy and etiquette for Wisconsin licensees. Finally, part 4 will be a review for your test. Let's start with how disciplinary proceedings are conducted against Wisconsin licensees. The Department of Safety and Professional Services is the Wisconsin administrative agency that regulates real estate licensees. Their authority is set forth at Wisconsin Statute 440. The statute describes the role of the DSPS by telling us the general duties and powers of the department, general duties and powers of examining boards, examination standards, and credential reviews. The DSPS regulates not only real estate licensees, but many professions that require state licensing, including, but not limited to, private detectives, behavior analysts, private schools, cremation and cemeteries, substance abuse counselors, nurses, pharmacists, physician assistants, podiatrists, midwives, athletic agents, barbers, boxers, and more. But for our purpose, the statute includes appraisers, home inspectors, real estate brokers, and real estate salespersons. The DSPS is a very powerful government agency that regulates and disciplines licensees. What exactly does the DSPS do? Let's start with their role of regulating you. The DSPS promulgates rules that are put into operation of law. Promulgate, by definition, means to make known by open declaration, publish, proclaim formally, or put into law. The DSPS also regulates the maintenance of your real estate license. They require examinations to maintain your credentials and require proof of continuing education, which you're working on right now by watching this video. They also investigate complaints against licensees and require reporting by licensees of any charges or convictions of criminal offenses and arrests. So the DSPS promulgates rules, requires examinations for licensure, and for completion of continuing education and the reporting of infractions committed by licensees. Their power is bestowed upon them by the Wisconsin legislature. Their rulemaking authority is then codified by statute. They promulgate rules that specify procedures for addressing allegations that a licensee has practiced while impaired by alcohol or other drugs and other things. They seek to facilitate, in that case, early identification of chemically dependent credential holders, and they encourage rehabilitation. They have the statutory authority to subpoena witnesses and require the production of documents prior to disciplinary proceedings. A person holding a credential who's convicted of a felony or misdemeanor anywhere must send a notice of the conviction by mail to the department within 48 hours after entry of the judgment of conviction. The department is basically empowered to keep criminals and incompetent licensees from harming the public. We have a general rule in this country that anyone accused of wrongdoing must be afforded notice of an investigation, the right to confront your accusers, the right to be heard, and the right to appeal any adverse action opposed upon you that affects your real estate license. The United States Constitution protects you from unlawful government interference. All laws that are legislated are governed by the Constitution. If the legislatures of federal, state, or even municipal governments interfere with your rights, then it's up to the judicial branch of government to review and declare if any law or rulemaking by any agency abides by the Constitution. And we know that we have federal and state constitutions. The Constitution is designed to limit government, not to limit people, and many people don't understand that concept. Let's look at the procedures promulgated by the department to investigate complaints against licensees. Well, anyone can file a complaint before the DSPS or the examining board to begin disciplinary proceedings against a licensee. In every proceeding, the burden of proof is the preponderance of the evidence. That's the legal standard used in civil cases where the burden of proof is met when the party with the burden of proof convinces the fact finder that there's a greater than 50% chance that the allegations are true. This standard is established when the evidence that's presented shows that it's more probable than not that the claim against the licensee is true. Now, the sanctions for licensee violations can be as follows. You can be reprimanded, denied a license, your license can be declared limited, they can suspend or revoke your license if you fail to respond to the satisfaction of the department or board within 30 days of a request for information from you in connection with the investigation of misconduct. If misconduct is established, the lowest type of penalty can be an administrative warning, whereby no further action is warranted if it's a minor violation. This occurs when the board determines that the warning adequately protects the public. However, if a warning is issued, the holder may request a review of the warning. If a warning is imposed, the warning doesn't constitute an adjudication of guilt or used as evidence of guilt. If there's a subsequent allegation to the initial warning, meaning you do it again, the issue may be reopened and the disciplinary proceedings may be commenced once more. If this happens, the new allegation can be used as evidence that you had actual knowledge of the misconduct that was the basis for the warning. An administrative warning becomes public record, but the contents of the warning are private and confidential. In other words, you were warned, but the actual facts of your misdeed can't be disclosed in the public record. Let's say you're operating without a real estate license. For example, you failed to complete your continuing education and you just continue to operate as though you're licensed. Well, what happens in that case? After a public hearing, the department can issue an order enjoining you from continuing from practicing. You're prohibited from using the title of salesperson, broker, or appraiser, for example. The department can take this even further if you fail to renew. They can petition a circuit court for a temporary restraining order injunction against you. That's if you want to renew, but you didn't. Well, you've heard of restraining orders. They're common when someone is, for example, harassing you or affecting your liberty. If you don't comply with the temporary restraining order, you can be fined up to $10,000 for each offense. And the state attorney general or county district attorney can commence an action to recover the forfeiture from you. And every day that you violate the restraining order is another violation and a separate offense. The cost of prosecution can also be imposed upon you. The costs accrue interest at the rate of 12% per year, and it's compounded annually from the date the cost was due or ordered. Your license won't be renewed until the costs are paid. The department can also cancel your license. In what type of situation would they impose cancellation? Well, if your renewal payment is denied by the bank for non-sufficient funds, then your license can be canceled on or after the 60th day after the department receives notice of the bank's NSF notice. And at least 20 days before the cancellation of your license, the department has to provide you with notice by mail. Once you receive the notice, you have to pay the renewal fee that's due, or if your license is canceled, you must also pay the late fee and pay any charge for the unpaid draft. But good news, the department can extend time for you to pay, or they can delay the cancellation of your license for a certain amount of time, allowing you to pay. And if your license is canceled, then it terminates any rights you have as a licensee. You can reinstate your license after paying a $30 reinstatement fee. The department must give you notice of renewal at least 30 days before your renewal date. This notice is sent via U.S. mail delivery to your address of record or by email. So you have to make sure that your contact information is current with the department for renewals or notice of investigation. The department can request information regarding an arrest or conviction. They can require you to provide that information that is necessary for the investigation. You want to update your address with the department if you move or change your name. Did you know that a failure to receive a notice of renewal is not a defense in any disciplinary proceeding against you or in any proceeding where you're accused of practicing without a license? The department removed this excuse. I guess in this case, the department figures that you should know when your license expires, and the failure to receive notice of renewal does not relieve you from the obligation to pay a penalty for a late renewal. The renewal dates now for a real estate broker, business entity, or salesperson is, write this down, December 15th of each even-numbered year. So for this continuing education biennium, your license will expire on December 15th, 2024. If you renew late, you can be restored by paying your normal renewal fee plus a late fee of $25. If you change your name or move from the last address provided to the department, you have to notify the department of your new name or address within 30 days of the change in writing or by another approved form of notification, for example, by email. You have to provide your email address, though, at the time of renewal to receive information from the department. But the department is prohibited from using email to deliver process service or notice of any demand of you. If you don't have reasonable access to the internet, you can provide notifications by regular mail delivery. The department or any examining board may serve any process notice of demand on you by mailing it to your last known address as indicated in the board's records. So I'm beating you to death on updating your information. And finally, your license can be restricted, limited, or suspended, or they can deny an application for an initial application to be licensed if you're delinquent in paying child support or fail to comply with a subpoena or warrant issued by the Department of Children and Families or a county child support agency related to support or paternity proceedings. Well, that concludes part 1 of 4 of disciplinary actions, and I'll see you in part 2.